think we'll kick off. So good afternoon, everybody. Thanks so much for joining us today. Welcome to Fraser Jones, our Irish employment legislation webinar. This is the fourth in our series with the fabulous Hilary O'Connor. My name is Claire Schindler and I'm the Regional Director for Ireland here at Fraser Jones. We're a global specialist HR executive search and recruitment consultancy. And at Fraser Jones, we place talented HR professionals with all sorts of organisations, from startups and SMEs to global FTSE organisations. And we support both permanent and interim projects. I lead the Irish business and have been in the recruitment industry in Ireland for over 25 years. We're a global consultancy along with our offices in Dublin. We also have offices in London and across the UK, across Europe, Australia, Asia, the US and the Middle East. So we're uniquely placed to support global organizations with all of their HR talent requirements. And as HR professionals yourselves, you know that employment law cases and decisions have significant impact on your day-to-day work and your HR policies. So to give us some insight, we do have Hilary O'Connor here to review some of the important decisions made so far in 2024. Hilary will be covering a significant recent unfair dismissal case and the outcome, along with a discrimination/reasonable accommodation case. Hilary will also be updating us on parents' leave and benefit, remote working, reference checking, and updates on maternity protection and statutory sick pay. I'm very pleased to welcome Hilary today. She is a solicitor and a legal consultant and is also an accredited mediator. Hilary is straight talking and she has significant experience in employment law. She qualified over 18 years ago and was elected to the Law Society Council of Ireland last year. Can I ask if you have any questions during today's session that you please add them to the Q&A box, and we'll answer those questions at the end of the session. Hilary will also share her slides with all attendees and will record this session for you or your colleagues to access later. So I'll now hand you over to Hilary and I hope you all enjoy the session.
Thanks so much, Claire, and good afternoon, everyone. Thanks so much for joining us again on this middle of the road kind of a day, middle of the week, and we will get going and hopefully you will enjoy the session. So we'll go straight to the case that Claire just referred to, and that is the Gary Rooney and Twitter case. You probably have heard about it because it was in the news, because it was the biggest award so far from the WRC. I just put in a bit of background to the case for context. So you might remember, because it was only 2 years ago, Elon Musk made a bid for Twitter, 44 billion in April 2022. The board resisted it and there was a lot of posturing between the two. Then there was a downturn in share price and Musk tried to withdraw from the deal in July. At that point, the shareholders had got spooked and they wanted the board to accept the offer. So Elon tries to pull out of it and then Twitter sued him to try and force him to complete the sale. So this was going on in the commercial court in the US, and it was going on in the October. And at that time, Elon tried to come back to them and say, will you accept less? And they were like, no. And the decision was he must go through with it. Now, Elon had been very vocal about how he thought Twitter was being run and the changes he was going to make. But there had been talk about that there was, all these false accounts. And so anyway, Elon had to go through with the sale. So it was a spooky time for Twitter. So he takes over and within a couple of days, he fires the senior members of the board, probably unsurprisingly, given the last few months. So he was very vocal also about the job cuts that were needed for profitability and the savings he would make. So getting back to Mr. Rooney, he had been employed in Twitter since September 2013. He was promoted 3 times, and at the time of Elon's takeover, he was the director of Source to Pay. He loved his job, and after the takeover, he was instructed to cancel all direct debits to suppliers and cancel all employees' travel expenses. This was without discussion or anything. So within 4 weeks of the change of the ownership, 50% of the employees were terminated. So you can imagine the unrest and what an unsettling period this was. So then on the 16th of November 2022, the employees receive an email. The email was entitled "A Fork in the Road," bizarrely. But anyway, this was the warm email from their new boss. Going forward to build a breakthrough Twitter 2.0 and succeed in an increasingly competitive world, we will need to be extremely hardcore. This will mean working long hours at high intensity. Only exceptional performance will constitute a passing a grade. If you are sure that you want to be part of the new Twitter, please click yes on the link below. Anyone has not done so by 5 p.m. ET tomorrow, Thursday, will receive 3 months of severance. Whatever decision you make, thank you for your efforts to make Twitter successful, Elon. So again, a nice warm email. So the next email, the following morning at 2:19, Mr. Rooney he got an email attaching a frequently asked questions document under the heading International, which applied to him because he was in Ireland. The document stated, if you do not confirm that you wish to stay at Twitter, you are resigning. You will not be entitled to statutory redundancy or other termination payments unless otherwise required by local law. We will comply with all applicable legal requirements, subject to local legal requirements. This voluntary separation offer is compromised of, and it goes on. So again, a very confusing email because you're not entitled to statutory redundancy, then it's subject to local legal requirements. It was bizarre. So the offer was also subject to a signed settlement agreement, which was not provided. So if you decided to stay and you did not know what kind of increase, so if you decided to stay, you didn't know what increase in your hours was expected, and you didn't know how your pay was going to change, because none of that was clear from these two emails. Additional information would be forthcoming in the coming days, which of course would be outside the click the box whether you're going to stay. So Mr. Rooney was he was also paid in stock, and there was no information about what would happen to the stock. And we'll see with respect to his pay that the stock made up a significant part of his pay. So there was confusion if you ticked the box to agree to more hours, but didn't know how many hours, and less money, but didn't know again how much less money. There was confusion if you don't tick the box, what was the exit package, but there was no details. And also contradictory that it wanted to stay, if you wanted to stay, that they would liaise according to legal obligations. So on the 19th of November, he didn't tick the box. And then on the 19th of November, he got an email acknowledging his decision to resign, which was effective from the 17th of November. So on the 26th of November, Mr. Rooney emailed and said he did not consider his inaction a resignation and did not consider the communication above to have sufficient information to make a decision, which is a fair point. So then he sent a further email on the 5th of December saying that he was still no response, and where is the separation agreement? The response then from the company says, this was on the 7th of December, 2 days later, he says, as you did not tick yes, you resigned, and therefore you're getting 3 months severance. So Mr. Rooney did not sign the severance, and he instructed solicitors to write to Twitter, and they did. They wrote 2 letters, but there was no response. So he initiates an unfair dismissal claim, and this claim was heard over 5 days, and it was much defended, and it was a hard fought case. So Twitter were relying on the failure to tick a box that this was a resignation. With unknown consequences to constitute a resignation. And Mr. Rooney claimed the contract had stipulated that the only acceptable resignation is by notice in writing, which is standard in most contracts. And he said that you can't rely on a resignation if it is induced by a threat, an ultimatum, or a misstatement. So that was his point. This is not a resignation. The inaction can't be a resignation. And even if his inaction could be a resignation, you can't do it if it's induced by a threat, ultimatum, or misstatement. And that's kind of settled law. So he says he did not resign. And if he did resign, it was because of the threat or the ultimatum. And he didn't resign, but the company, if he did resign, the company are obliged to accept a withdrawal because of the lack of information. So if any of those were present, then this was an unfair dismissal. So his basic salary was 137,000 plus pension and share contributions of 230. So his total package was 370,000. There's a bit of work. There was a bit of working out of his salary, and they agreed it later on, which we'll go through. So this happened in the November. He was paid up till the December. And it took him until the following September to secure employment. And this employment was at 108,000 plus pension and a car at a total salary of 130,000. So a significant reduction compared to the Twitter job. So he argued that his financial loss was great because he will be unable to find a job which is financially as rewarding as the Twitter job. So this loss is capped at 104 weeks, but his loss would be greater and would be going into the future. So the respondent tried to argue that he was obliged to raise a grievance if he was aggrieved because he didn't have enough information in order to make the application. They also argued that his internal communications with peers confirmed he was not clicking yes and therefore resigning. So they produced internal communications where they had said, God, this is wild. I'm not ticking yes. And, he'd been chatting to his peers. And he also tweeted on the 17th, which was the day of the deadline, after 9 years, I am out too. So this email, the Fork in the Road email, had been sent to 270 employees in Ireland, and 235 of them clicked yes. So you do wonder, but it was such an uncertain time, and I get why people would click yes, but I also completely understand why people wouldn't. But this is the risk that Elon took, and he saw the gains to be made by doing this. So held that was not put forward that he was locked out of the systems by virtue of the internal communications, but because he did not click yes. So this argument that he should have raised a grievance, sure, he was out of the systems immediately after the deadline. The adjudication officer found that he was terminated because he did not click yes. The failure to click yes could not and did not constitute a resignation, and therefore it was an unfair dismissal. Regarding the award, then the adjudicator adjusted the figure from 370 to 323,560, and still a huge salary, and calculated that his monthly pay was 26,963, and so he was paid up until the December. And he did secure a job in the July, but he didn't start until September because he was going on holiday in August or something. So the adjudicator says, well, the employer can't be penalised for you going on holiday. So it was 7 months' pay. That was 188,741. So then his new job was 10,824 a month. And that was a difference of the 16,139 from the date of our date of his employment, which was in September, to the date of the hearing, which was in May. So that totaled 161,390. So with regard to the future losses, Mr. Rooney had argued that he would never get a job, even close range to that pay. And he was awarded 200,000 for that. So the total award was 550,131. And when you hear those kind of awards in the news, they are eye-watering. But I suppose when you look at the pay, his pay was eye-watering to a lot of us anyway. So the award, if successful, you're always going to go there. But the other thing to note is, as I said, this case was heard over 5 days, and his legal costs, he had to pay his own legal costs, which were going to be north of €100,000. So this goes back to whether Elon, you know, what he was doing by sending that email. He knew a lot of people can't afford to do that, and they need certainty of pay. And so only 35 didn't tick. Out of the 35, I don't know what the statistics are, who took a case. So Mr. Rooney did, and he was successful. And but I suspect Elon is making his savings as he promised. So that's that. I thought that was a good case to kick things off. So then this is in respect of discrimination, reasonable accommodation. So this is a, you know, I mean, talking about going from a massive award to not so massive award, but it's more the point. So this is Christian Brown and Kilkenny Limestone Quarries Limited. So here there was a claim for dismissal on the grounds of disability, and the claimant at the interview advised the employer that he suffered seizures. He was hired as a general operative, and the respondent requested more information about the seizures. The claimant gave him posters actually about what to do if I do have these seizures. So he began work, and a couple of weeks into his job, he had a seizure in the canteen, and he had some time off, and then he returned to work shortly after that. And then there was a meeting, and he was dismissed at this meeting. He was 5 weeks in the job at this time. The claimant's evidence was that he was told he was a good worker, but they had to let him go because of the seizures. The respondent's evidence was that he had not passed the probation, and he was not meeting the output targets. But then in evidence, the respondent admits that she didn't necessarily consider the seizures to be a disability. She admitted that it was a work in progress to try and understand the disability, and she didn't have any minutes of the termination meeting. There was no termination letter, because after the dismissal, things became quite heated because members of the claimant's family were calling the respondent, and she says she didn't want to send a termination letter because things were so heated. So she admitted that the probationary period is 6 months, and she couldn't explain why she couldn't give him longer in the job if she was dismissing him because of the probationary. So with regards to reasonable accommodation, she said she'd made an appointment for him at the doctor's, but she had no report, and she said she didn't follow up with the report. Now, there was no evidence from the claimant that he'd gone to the doctor. The claimant had been they were self-represented, or he was self-represented, like he represented himself, lay litigant, they're the words. And so that wasn't asked in evidence. So the respondent company had said they didn't follow up on the report regarding recommendations for reasonable accommodation. So then the owner of the company said that the machine that the claimant had been working on had KPIs, but he wasn't giving the statistics regarding the machine, and he couldn't produce them either at the hearing. So remember, their case is that he was dismissed because he wasn't making the targets, but they didn't have the targets there at the hearing, and they also said they never gave them to the claimant. There was no risk assessment made regarding the machine and the complainant's disability. The disability did not come to light until a few days after hiring him, and they accepted that this was a disability, and the respondent also accepted that they were told of it. So there was no evidence either of a probationary review, and the decision was that there was a clear link between the seizure and the dismissal 3 or 5 days later, and this was held to be discrimination by the respondent. There was a €3,000 award made, but it would have been more, but for the lack of candour by the complainant. So they weren't successful in the reasonable accommodation claim. And so it's just the point is there, you are judged on what you do when you're notified of the disability, and it needs to be immediate. Now, €3,000 compared to the Twitter claim, of course, is small change, but €3,000 for an employee that was only there for 5 weeks is significant. And it's significant because it's €3,000 that had the HR there dotted their I's and met and could produce the report from the doctor and all those little things. That's €3,000 that you didn't that you weren't liable for, and you could successfully defend that claim. So moving on. So just by way of updates, the auto enrollment, which I talked about, I think in the March review, you know, there was talk that this was going to be ready for this quarter, but it's not. So now it's going to be September 2025. So I'm just saying again, you need to speak to your pension advisors in order to get that set up. Then, of course, we've heard in the budget just recently the minimum wage is moving from £12.70 to £13.50, and this is for workers over 20 years of age. It'll be effective from the 1st of Jan. And then parents' leave, this is up from 7 to 9 weeks. It's effective from the 1st of August 2025, and this is for the parents of children within the 2 years of the child's life, or if adoption, it'll be 2 years of the child being placed for adoption. You must give 6 weeks notice in writing to the employer. So this has gone from 2 weeks to 9 weeks in 4 years. So it's now become significant leave. It's not transferable between the parents unless one parent dies. So the parents' benefit then is the money part of it. So that's payable by the Department of Social Protection, €274. It's linked to the PRSI contributions. It's paid to employees and self-employed. Is a top-up at the employer's discretion, but it's less common. And during the parents' leave, your annual leave, the employees' annual leave accrues and the bank holidays accrue. Okay, so the next bit then is back to the office. And I thought this was interesting because there is now a shift on back to the office, and there should be probably a question mark there. So it's what's happening. So we're seeing a gradual push from fully remote to the office, and you guys will know all about that. And it's for collaborative and creativity. There has been different studies on the productivity, the impact on productivity from people working remotely. But we're used to the hybrid model being the norm. And in September, Amazon announced that from January, all of their employees in Ireland are coming back 5 days. So on that, I just said I would have a look and see who's doing what. So in Meta, those who aren't hired as remote workers are at 3 days. Stripe are at 50% of the time. Google 3 days. Microsoft 50%. Apple 3 days. And so just to bear in mind that the remote working request is here, and then to not fall into the traps of your decision of discrimination. So then I went from there to the remote working case law. So the code was expected in January as a result of the right to request remote working. It was expected in January and it came in on the 7th of March. So this case is linked to that. And it's the first case, I think, that we've heard on the remote working. And, you know, as HR people, you know, employers were up in arms about this right to request remote working. They were nervous about it, that they were going to be compelled to do it. And, you know, they were waiting for this code. So the code comes out, and anyway, we have our first case. And I think from reading the case, employers can, you know, breathe a bit easier, but I suppose they'll always be roused. But anyway, we'll go through the case. It's Alina Karaboko and TikTok. So she was employed in January 2022 during COVID, but she works remotely, but her contract said the office is in Dublin, and that's her place of employment. In July 2023, there was a request for people to come back to the office for 3 days a week. And this was effective from October 2023. And the reason was for in-person collaboration, which we discussed there a minute ago. So she made an exceptional request, which was refused. And then she herself refused to return to the office. So disciplinary was initiated there, and she got a verbal warning in February 2024. So the code of practice came out then on the 7th of March 2024, and she requested remote working in March 2024 on foot of, and I have that after these slides, you know, the code, what the code says. So pursuant to that code, she makes the request, and she had put in her reasons was to reduce her commute, her carbon footprint, and the lack of suitable accommodation in Dublin for her and her cat. This was refused on the basis of in-person team collaboration. The refusal letter significantly stated it had considered her needs. So section 24 or section 27 specifically states that there's no power on the adjudicating officer to assess the merits of the decision. So this, as I said, is giving comfort to employers. So once the employer complies with the timelines of the request and considers the needs of the employee, they have discharged their duty. So the focus on this act is on the process, not on the decision. So, you know, that is, will give employers comfort, but employees will be climbing the walls. So section 21 sets out the 3 duties the employers must comply with, and the guidance for these requests is set out in the code. So then I have put in the remote working requests. So what is remote working? It's an arrangement where some or all of the work ordinarily carried out by an employee at an employee's place of business under a contract of employment is provided at a location other than at the employer's place of business without change to the employee's ordinary working hours or duties. So then the right to request remote working, and apologies to those who were here at the June webinar because we went through that, but I put it in here again because this is what you need to comply with now as an employer when you get this right to request. In accordance with that case, they says as long as you comply with the deadlines and if you consider the needs, then that is all you need to do. So this is all employees can request, but must have a minimum of 6 months continuous service before the remote working can start. It must be met as soon as practical, but no later than 8 weeks before the remote working is to take place. The right to request remote working must be in writing and signed by the employee, but may also be online, and include the details of the remote working arrangements, the proposed starting and end date, if relevant, the reasons for the requesting the remote working. So this is the employee's chance to set out to their employee how they are confident that they can continue to perform their role remotely, to the required standard and their individual specific reasons for making the right to request. So the code gives examples of reasons for requesting remote working and include reducing the daily commute, carbon footprint, there you go, that she had used that, optimizing quality of life outside normal working hours, personal or domestic circumstances, neurodiversity or special needs. The application must also include details of the proposed remote working location. Where are you going to be working? Is it at home? Is it at a hub? Where? So the employer needs those details. And then the information on the suitability of the proposed location, which should include the following information: the workstation, the distance of the proposed remote working to the employer's on-site workstations, all that sort of details. I won't go through it because it's there. You have the slides, and that's what you can read that yourselves. So then these are what the employer must do. They right to respond. So you must respond within 4 weeks, and this can be extended by another 4 weeks, but they must. So then the employer must approve the request and provide the notice in writing to be signed by the employer and employee, setting out the details of the arrangement. So if you're approving it, it's a signed kind of agreement. And then if you refuse the request, set out the reasons for the refusal. And if you need more time, say how long more. So the employer must keep the signed agreement and send to employees. And you see, you do have to keep your records and things like that. So this stuff is important. So the employee must consider the needs of the business, the request, the reasons from the employee, and may consider the code when requesting or when considering this request. So you must be fair, reasonable, and objective when considering. So the consideration for the employer will include the type of work, whether it is manual, does it require technology, which is on site only, does it require interacting with clients in person, would it affect the quality of work, any health and safety concerns. The employer will also consider the employee when making a decision. So if the employer can't agree, they should consider alternatives and engage with the employee and see if there is an alternative can be agreed. An agreement to remote working may change an employee's terms and conditions of employment. So what they're trying to encourage is that you engage with the employee, I suppose, to save them be the adjudicator and to save applications going into the Workplace Relations Commission. So then remote working can be terminated before or after it has started if the employer is satisfied that the arrangement would have or is having an adverse effect on the business. The employer can give notice terminating the arrangement, having considered the business, the employee's needs, and the code. So the notice must set out the reasons for the termination and specify the date on which the employee must return to their original working arrangement. This date must not be earlier than 4 weeks from the date of the receipt of the notice. So an employer who proposes to give notice terminating must first notify the employee in writing of the proposal to terminate and include the details of the grounds for terminating. Give the employee 7 days after the receipt of the notice to respond and consider any response the employee makes before deciding whether to go ahead. So the employer's reasons must be clear, objective, and reasonable. They should set out to the employee that they can understand the reasons. So penalisation, an employee cannot be penalised for availing of requesting the remote working. If there's breaches, you can make a complaint under the employer's grievance policy or make a complaint to the WRC. So they are trying to get people to engage rather than go to the WRC. The complaints to the WRC can be made within 6 months of the decision. The WRC can only adjudicate on the process employed by the employer and not the merits of the decision. So there's awards of up to 4 weeks pay may be granted. So that's the point for you guys, adhere to the process because the merits won't be adjudicated. So if you don't adhere to the process, it's a 4 weeks pay. And then you have to keep the records for 3 years. So that is that fun piece over. And then just for a finish, we're almost finished. I just put in reference, which is something that I've come across regularly, actually in my own work, but of which is again topical. For those of you who are listening to the news and have heard about the debacle in Sinn Féin over the reference. So just going through who can give a reference in your organization, the consequences of giving a reference without authority. So going on to the Sinn Féin controversy, there was an allegation and then charges against an employee in the press office in Sinn Féin. The employee then pleaded guilty to child sex offences and actually is due to be sentenced next month. But he was suspended when the allegations came out, and then his employment ended. So he went from Sinn Féin and then went on to work in the British Heart Foundation. And the Heart Foundation had got 2 references from Sinn Féin to secure, in order to secure his employment. These references were from 2 colleagues and were given without authority from the HR manager, and they acted entirely unilaterally, and I think that's accepted. They, of course, faced discipline when this came out, and they left of their own accord, probably before they were dismissed. But the fallout is for Sinn Féin, because the reputational damage is huge, and it hasn't left the headlines. It hasn't left the news in 3 weeks, I would say. So it's just the consequences for your organization of an employee going about their own reference. And I've seen it, as I said, I acted for somebody in an unfair dismissal a little while back, and amongst they had clubbed a number of offences against him, but he had given they found in his email that he had given references to some general operatives, to other employees, for employees, and they had clubbed this and other matters and to a gross misconduct, and they were sued for unfair dismissal. But it does happen, and it's just having a robust policy is your basic. But people need to be told in organizations you cannot give references without it going through the proper channels. So I just thought it was worth highlighting. So then looking ahead, I think the maternity protection bill, of course, they have now acknowledged that there is going to be an election in the next couple of weeks, which when I was even doing the slides for this, they were saying, no, not till February. But anyway, it's going to be in a couple of weeks, but they are hoping to get the maternity protection bill ready, and that'll go through. This will pause the maternity leave for up to 52 weeks for a woman who has had a serious diagnosis and is undergoing treatment for a serious illness. So that is a positive, certainly for those small amount of women, but it's significant. And then statutory sick pay from January 2025, that's to go to 7 days. The usual criteria: you must be an employee in continuous service for 13 weeks, and it has to be certified by a doctor. And you're entitled to 70% of pay, up to a maximum of €110 per day. And there is talk of it being postponed, but nothing yet. So that is it. I hope you're still with me and utterly...
Everybody's still with us, Hilary. That's good. That's the good news. We have a few questions here, if I can run through them. So do we know if Twitter received local or country specific HR and/or legal advice on their approach, or did Elon just go rogue and apply a global approach, ignoring any potential country specific employment rights or laws?
Yeah, so I mean, could you imagine being the HR director there? So I think he just did his own thing. I mean, I can't imagine that any anyone says, oh yeah, that email looks good, send it off. But there was nothing about that in the case. And I mean, it took me like a long time to read the case. It's quite lengthy, but there was nothing on that. But their argument was purely, this was a resignation. He resigned. He had tweeted about it. He had communicated internally about it. This was a resignation. And his point was, like, this was an ultimatum, tick or don't tick. You're either in, you're out. And if you're in, you say more hours, less pay, we can do whatever. Now, it did come out at the hearing that Twitter didn't deduct anybody's pay at that time. Now, that was the case went on in May and the decision was out in August. But I don't know, like, I mean, you've signed that you're okay with it. You've ticked the box. I mean, is that valid? All of these things haven't been tested. But no, he seemed to apply a global approach, Claire.
Yeah. Okay, brilliant.
What a boss.
Is the parents' leave increase applicable since August 2024, or is it August 2025 that's coming in?
2024.
Okay, perfect. So since August 2024. Yeah. Okay. If an employer offers a specified remote work outside of country policy 4 weeks in a year, would the remote work request operate separately to the out of country work request? Oh, I get this. So if an employer offers a specified remote work outside of the country policy, so a lot of companies are now giving you, you know, up to 6 weeks out of country remote working. Yes. Would the remote work requests operate separately to the out of country work requests or alongside it?
Well, I suppose that is up to the company. So if the person wanted to request remote working, then that remote working would set out what you're requesting, and if it includes or excludes those 4 weeks. Am I understanding your question?
Yeah, I think that's correct. Yeah, because a lot of companies are now providing you with a certain amount of time that you can work in another European city, or, you know, there's a lot of people maybe that are international employees but based in Ireland, and they want to go home to Italy for 6 weeks, but they also still want to work, you know. So I think I don't know if they're two separate things, the remote working.
Well, I think when you set out your request, you set out what you are envisaging. And I guess the employer can say, but hold on, aren't you, like, are you looking for 3 days a week at home, like forever? Or what are you looking for? And then the employer can come back and say, but haven't you got the 4 weeks that we've already, you know, so there can be to and fro, but I would see that as an addition, as an add-on. But then again, it would depend on the company and what is the policy, do you know? Yeah.
Yeah. If the employee is contractually obliged to work from the office 5 days a week, can they still request remote working?
Yeah, they can request it, but the employer doesn't have to go with it. And that's the thing. So, you know, and it is different to the reasonable accommodation. Yeah, it looks like the right to request remote working is not as strong as originally thought. But then again, you know, case law changes these things all the time. And that is only the first case because the code only came in March. So she was straight off immediately, you know.
And what, the next question is about reference checking, actually. Can you write a personal reference for somebody, but not on company headed paper?
What you're writing it in your capacity as the HR or Hilary O'Connor solicitor, you know, what is the capacity? And what are you saying in it? Are you saying, you know, Claire works really well, she's reliable, she's done this? Or what are you saying? Are you saying Claire does loads of charity work? Or what are you saying? What is the reference? What is the purpose of the reference? And what is the person, the receiver of the reference, what is that purpose? Is it to see, are you good at your job, or is it, are you a good person, or whatever? In the Sinn Féin matter, that was purely for him to get a job in the British Heart Foundation. So,
Right.
you know, that's that. And at that time, those allegations, there was allegations, he had left because of the allegations moved to charges, and then he pleaded
Yeah.
guilty. So that's why it is
Yeah.
huge. But Sinn Féin are left with that. The brand is
Yeah.
left with it. And it
Yeah.
was, those employees did that. They went off rogue and they did it themselves, you know?
Yeah. Okay. We've loads of questions today. If an employee's request for remote working does not meet the requirements of the code, can it be refused without consideration?
So if the employee's request doesn't meet the code, like if the employees, in what way do they, because they don't specify, you know, where they're going to work, or if they're going to, what they're going to do. Like as long as the employer considers it within the 4 weeks, then they go back and say, that doesn't, I need more information. Like, I don't think you'd say that doesn't meet the standards of the code. You just say, like, you haven't given me this information. Can you give that information to me?
Yeah.
So yeah.
The next one's quite interesting. So the Twitter situation aside, some people do disappear and do not respond to any contact. When several attempts are made and requests made for contact are made and requests are made for contact, we will take a view that the person has decided to resign by reason of their lack of contact or response. Can you see an issue here?
Yeah, because
there is
because so that inaction or that lack of a response should kickstart your own disciplinary policies. And then you go through that. You say, you haven't responded, blah, blah, blah. I'm inviting you to a disciplinary meeting, or I'm inviting you to an investigative meeting to see why you're not responding. And then they don't respond to that. Then you write to them and say, you haven't responded to that. So now we're going to escalate it. And you give them the procedures. So you're always on a journey somewhere. So if the employee has done something, you invoke disciplinary. And if the employee has a problem, they invoke grievance. So you're always floating between those places, but it's never like, oh, they're just gone. Because you have, and I mean, that happens, right? I get it, but make sure you're covered, because like I like back in the day, there was so many people that say when people would go out on sick, when P45s were the ending of an employment, and then they could be gone for a year or whatever, and a P45 would arrive in the post, and next minute it's an unfair dismissal. You know, it's like, oh, I haven't heard
those
from you.
days.
And like, so these obligations, as long as you're clear in your policies and your obligations, then you go back to those obligations and saying, you haven't responded to any of my messages. I need to know what you're doing. I need you to have this meeting. You didn't come to the meeting. Well, then blah, blah, blah. So you always go back to your policies. That's why the policies are so important to have them.
Yeah,
you know?
Absolutely. Well, just one last question. If a remote working request is approved and goes on for a significant amount of time, example, a number of years, at what point does it become custom and practice? When does remote working become their normal place of work and cannot easily be rescinded?
Well, employers will be very reluctant to say your home is now your place of work, unless you were hired completely for a remote working position. So it becomes custom and practice when, you know, there's a problem and you go to the WRC and the WRC says it's so long in being that it's now custom and practice. So like my advice to the employee would be just like, keep the head down and say nothing. Don't be, you know, that would be my advice to the employee. The employer as well, I would say, don't change it. Don't change it. Yeah.
Keep it. Okay, brilliant. Thank you so much, Hilary. It's been a brilliant session. I really, really enjoyed it. I hope everybody else did too. Thank you to everybody who joined us. I'll be sending feedback forms to everybody as usual. So please do provide us with feedback. It really allows us to understand how these sessions are being received and what we can do differently to in relation to your own opinions. We'll share the slide deck with all attendees so you can review at your leisure. And feel free to reach out to me directly if I can be of any assistance in the future. Hilary's contact details will also be sent to you. So if you have any legal or mediation requirements, I can't recommend Hilary enough. And if we're not connected on LinkedIn, please do send us a connection request. We'd love to include you in our network. And we hope to see you all at the next session. Thank you so
Super.
much.
Thanks so much.
Thanks.
Cheers, Claire.
Bye.